The plot thickens in Michael Irvin's $100 million lawsuit against Marriott for defamation and the Jane Doe employee who accused him of misconduct and got him canceled from the NFL network. In this video, we'll look at highlights from Marriott's new motion to dismiss, including new details about the allegations against Irvin that led the NFL network to cancel him from his TV appearances. Now, before we dive into the video, a quick disclaimer: this video is not legal advice. Now, with that out of the way, let's get into the news. On February 27th, Marriott filed its motion to dismiss for lack of personal jurisdiction, or alternatively, to change venues to a federal court in Phoenix. Let's go ahead and take a look at the highlights from Marriott's motion to dismiss. As you can see here, Marriott filed its motion to dismiss on February 27th in federal court. So in the first sentence, it states that plaintiff Michael Irvin's claims in this action relate exclusively to his own alleged actions and statements and the alleged actions and statements of employees of the Renaissance Phoenix Hotel and Spa in Phoenix, Arizona. Footnote to point out to the court and the public that Michael Irvin has referred to the hotel throughout his complaint erroneously as the Renaissance Phoenix Hotel and Spa, which does not exist. Now, this is somewhat of a petty point to make because I looked on the website and yes, they are correct. It's technically not called the Renaissance Phoenix Hotel and Spa. It's actually the Renaissance Phoenix Downtown Hotel, but that is totally irrelevant to the issues in this motion. We call a footnote like this barking from the bottom, and that's because they're making an argument that's really irrelevant. It's just taking a petty, cheap shot at the other side and their, I guess, carelessness in drafting the complaint in a footnote at the bottom of the page. So on the next page, it states that plaintiff cannot show that any of the necessary elements of personal jurisdiction are met here. Then it goes on to say, first, as a matter of law, the court does not have general jurisdiction over Marriott because Marriott is not incorporated in Texas, does not have a principal place of business there, and cannot otherwise be considered at home there. Those are the three ways to establish general jurisdiction over a corporate defendant. And then it says, second, the court does not have specific jurisdiction over Marriott. Marriott is basically arguing that the court doesn't have specific jurisdiction over a defamation claim in Texas because the defamation didn't occur in Texas. Nothing that is alleged in Irvin's complaint actually occurred in Texas. Then Marriott goes on to ask alternatively, if the court does not dismiss this action, that Marriott respectfully requests that the court transfer the case to the District of Arizona pursuant to this statute right here, 28 USC 1404A, for fairness, reasons, and the convenience of the parties. None of the relevant documents or witnesses other than the plaintiff are in this judicial district, that being the Eastern District of Texas. And then it goes on to say, Arizona law is likely to apply to plaintiff's tort claims, that would be the defamation claim, both of which arise out of conduct that plaintiff concedes occurred exclusively in Arizona. Thus, the court should transfer this action to the District of Arizona if it does not dismiss it outright. Then moving on to this page right here, page 4, Marriott argues that it had so limited contacts with Texas that it should not have to defend a lawsuit in Texas. First, Marriott points out that it is a Delaware corporation and that its principal place of business, that would be the corporate headquarters where the C-suite executives work and where its main office is in Bethesda, Maryland. And then it goes on to say the company has franchising and licensing arrangements that permit hotel owners and operators to use many of its lodging brand names and systems. That would be Renaissance, would be one example of a Marriott hotel brand name. As a franchisor and licensor, Marriott and its affiliates do not own, operate, manage, or handle the day-to-day operation of the hotel. So Marriott appears to be arguing here that it actually only licensed or franchised its brand and its name to whoever the third-party owner of the Renaissance Hotel in Phoenix is. But if we go on to the website of the Renaissance Hotel Phoenix, Marriott's name is all over it. So if you actually pull up the Renaissance Hotel in Phoenix and you scroll around, it seems apparent to me that Marriott does own this hotel, or that its branding is on it, that it certainly has a financial interest in this hotel. For example, the Marriott Bonvoy name is right here in the upper right. Then if you scroll down to the middle of the page, you have the Marriott rewards program, Marriott Bonvoy Boundless card. Then if you scroll all the way down to the bottom to the Your Privacy Rights link for the Renaissance Phoenix Hotel and click on that, it does take you to none other than the defendant in Michael Irvin's case, Marriott International Inc. Right there, all rights reserved. And so clearly, Marriott appears to at least have a licensing or franchising arrangement with this Phoenix hotel that bears its name, Renaissance. Now, moving back over to Marriott's motion. Now, Marriott goes on to say down here on page 4 of its motion that approximately 598 of the properties that Marriott manages, franchises, or licenses are in Texas, reflecting only about 7.2% of the properties in its global portfolio. As of December 31st, 2022, Marriott did not own any of the Marriott affiliated properties in Texas. Marriott does not own any hotel, residential, or timeshare properties in Texas and only directly employs approximately 200 employees in Texas out of approximately 140,000 worldwide employees of Marriott and its subsidiaries and affiliates. So moving on to the argument section of Marriott's motion. First, Marriott argues that it is not subject to general jurisdiction in Texas. It goes on to explain that general jurisdiction permits a defendant to be held into court in the forum state to answer for any of its activities anywhere in the world. It is blind to the facts and circumstances of the dispute. In other words, general jurisdiction is a way to bring a party into a court in Texas, for example, no matter where the activity that they engaged in took place. Well, a corporation is considered at home in its principal place of business and state of incorporation. And as we already saw in this introduction of this motion, Marriott is neither incorporated in Texas nor does it have its headquarters, its principal place of business in Texas. Now, in this paragraph right here, it states, under this standard, the court does not have general jurisdiction over Marriott. The only connection to Texas that plaintiff has alleged is that Marriott is, quote, registered with the Texas Secretary of State to do business in the state of Texas, end quote, and may be served with process via a registered agent in Texas. Marriott then says this is woefully insufficient to subject Marriott to general jurisdiction in Texas under well-settled law. And then it says, see, for example, and cites a case from the judge in Irvin's actual case, and then summarizes that holding from the same judge that no general jurisdiction, even taking plaintiff's assertion that defendants maintain a business presence in Texas as true because, quote, the Supreme Court has made clear that doing business within a state is no longer a sufficient basis for general personal jurisdiction. In other words, Marriott is arguing, Judge, in a previous case, you ruled that just because we do some business in Texas, that's not enough to establish our general jurisdiction in Texas. And we don't have our principal place of business in Texas, and we're not incorporated in Texas. And therefore, let us go to a different state to defend this lawsuit. That's basically what Marriott is arguing here. And it's pretty effective. But Irvin can still require that Marriott face a lawsuit in a Texas federal court if he can establish that the court has specific jurisdiction over Marriott in Texas. Can he do that? Let's take a look at Marriott's arguments here. First, Marriott lays out the law, which states that for a court to exercise specific jurisdiction over a defendant, here Marriott, a plaintiff, here Irvin, must establish that the defendant, number one, purposefully directed activities at or consummated some transaction with the forum, that would be Texas, or performed some act by which it purposefully availed itself of the privilege of conducting activities in the forum state, thereby invoking the benefits and protections of the forum's laws. And here, I think that Irvin can satisfy that element because Marriott was doing some degree of business in Texas. It had at least 200 employees, as it admitted earlier in this motion, and it was licensing and franchising, I believe, some of the hotels in Texas, even if it didn't itself own and operate any hotels in Texas. But let's move on to the second element, which I think gives Irvin some problems here. In order to prove specific jurisdiction over Marriott in Texas, Irvin must prove that his claims arise out of or relate to the defendant's forum-related activities. That means Marriott's activities in Texas are what give rise to the lawsuit. And I think that might be where Irvin is unable to establish specific jurisdiction over Marriott, because everything that has happened in this lawsuit, according to Irvin, happened in Phoenix. Then on page 11 of the motion, Marriott says, in short, plaintiff's claims have no relation to Texas whatsoever, let alone Marriott's extremely limited contacts with the state. Then the Marriott goes on to argue in the alternative. That means if the court denies its motion to dismiss, Marriott is respectfully requesting that the court transfer, at the very least, transfer the case to the United States District Court for the District of Arizona, Phoenix Division, pursuant to 28 USC 1404A for the reasons of fairness and convenience to the parties. And then it goes on to argue that the court should transfer the case, if it doesn't dismiss it outright, to the Arizona federal court, because all of the relevant documents and physical evidence are likely to be found in Arizona, while none are in Texas, let alone in this judicial district, the Northern District of Texas. Then on the next page, page 14, the Marriott Hotel argues any necessary third-party witnesses are the hotel guests or patrons and hourly employees of the hotel who were witnesses to the alleged interaction between plaintiff and a hotel employee. Those witnesses are likely to be local employees of the hotel, not Marriott, and individuals visiting for the Super Bowl from numerous locations. Then on the next page, it states that here, majority of willing witnesses, for example, hotel management and employees over whom the hotel and or Marriott can exert control. And this and or Marriott is indicative that Marriott does have some degree of control, even if not operational control, but ultimate control over the employees at that hotel. So it's a little bit disingenuous to be arguing that Marriott does not own or operate this hotel and shouldn't even be sued in this lawsuit, when it's acknowledging right here that it can exert some degree of control over the hotel management and employees. And then its brand name is plastered all over the Renaissance Hotel Phoenix's website and in the terms of service and the privacy statement. So again, it's a little disingenuous of Marriott to be trying to argue that it has no business being a defendant in this lawsuit. Then Marriott states that other than plaintiff himself, who has admitted to the media outlets that he cannot remember what happened at the hotel because he had been drinking, the most important witnesses in this case will be the hotel employees who were involved in or witnessed plaintiff's alleged interaction with another hotel employee and plaintiff's alleged removal from the hotel, as well as the hotel manager who allegedly contacted the NFL. So right here, I think we get a little sneak preview of what Marriott is going to be attacking Irvin on. So I think right here, we see a little sneak preview of what Marriott is going to be arguing in his defense. It's going to be attacking Irvin as having a sloppy memory of events because he admitted to this media outlet that he had been drinking that night, and he didn't necessarily say I was drunk or anything like that, but that is certainly what Marriott is going to try to create a picture of Michael Irvin being really fuzzy in his memory and a he said, she said type of thing. That would not make sense if the Marriott has hotel footage showing a perfectly harmless interaction. So if Marriott is going to be attacking Irvin for having a fuzzy memory of the night of events and trying to undermine his credibility by claiming that he had been drinking and therefore is unreliable in his memory of what happened, but it has surveillance footage that vindicates him, that shows that he did nothing wrong, then that argument is going to look really weak and silly, quite frankly. And so we need to see the surveillance footage, basically, is what this comes down to. And then finally, in the conclusion of this motion, Marriott states that for the reasons shown above, Marriott respectfully requests that this court dismiss this case under Federal Rule of Civil Procedure 12b-2. Alternatively, if the court declines to dismiss this action outright, Marriott asks the court to transfer the case to the U.S. District Court for the District of Arizona pursuant to 28 USC 1404A. So you might be wondering what could happen next, and what about that surveillance footage? Several things may happen in this case. First, Irving may ask for permission to conduct what's known as jurisdictional discovery and hold an evidentiary hearing on personal jurisdiction. In seeking jurisdictional discovery, Michael Irvin would want to be sure to tell the court specifically what discovery is being sought and why that discovery will show that the defendant has the minimum contacts with Texas so as to support personal jurisdiction. But courts are quite reluctant to grant evidentiary hearing over something as procedural as personal jurisdiction. And so here, I don't believe that Irvin is going to pursue that path because it would only drag things out further into the future. And he could just go ahead and file in Arizona court and pursue his claims there if the court grants the Marriott's motion. So that's all I've got for you today. If you like this video, let me know by giving it a like. Make sure to hit that subscribe button below and turn the bell notification icon on so you don't miss any of my updates on this case. And of course, as always, thank you for watching.